affiliate websites. And we hope this becomes a great turnaround tool for small businesses in the post-pandemic era. So my name is Dan Schneider. I'm the executive director of the Florence Belsky Charitable Foundation, one of the sponsors of today's webinar. Our organization is a 501c3 nonprofit whose mission is to connect people so they could share information and empower each generation to teach the others. We have a wonderful panel planned for you today. And I would like to now introduce our Associate Director, Rivka Rivera, who will explain some of the housekeeping rules for today's panels and webinar, and will then introduce some of our experts. Thank you all for coming.
Thank you, Dan. Hi, everyone. Welcome and Happy New Year. Thank you so much for joining us for this really important webinar. We're so grateful to our panelists and for you all to be joining us in this room. Just a few housekeeping things about Zoom. We will be having a Q&A towards the end, but please feel free to use that Q&A box whenever a question emerges for you throughout this panel discussion. And if it's not answered, we will definitely get to it at the end. And that's about all for housekeeping. Without further ado, we're going to start by introducing you to Andrew Rigi, who is the Executive Director of the New York City Hospitality Alliance. And he's just going to give us an overview and a little introduction about what's going on with the restaurant industry at this current moment in time. Thank you so much. Welcome, Andrew.
Great, thanks, Rivka. Hi, everyone. So I'm Andrew Rigi, and first just wanted to thank all our partners in hosting today's conversation. There's so much going on in our industry impacting restaurants and nightlife venues, and really it's an impossible situation, but the one thing I continue to say over and over again is knowledge is power, and all these incredibly difficult decisions business owners need to make, they need to be informed decisions, and that's why forum being held today really help you better understand what your options are moving forward in this extremely uncertain time. So, first, to put things just into perspective, the New York City hospitality industry, so restaurants, bars, and nightclubs, are vital to not only the economic fabric, but also the social landscape of New York City. It doesn't matter what industry you come from. You can often relate to food and drinking and socializing and going out. And in order for New York City and our nation, frankly, to come back and recover from COVID, we're really going to need the hospitality industry to be at the core of the recovery. So just here in New York City, what does this industry mean? Well, pre-pandemic, there were more than 25,000 eating and drinking establishments throughout the 5 boroughs of New York City. They employed about 325,000 people. Back in March, after the initial shutdown of indoor dining, when you look at the April jobs figures, they plummeted from 325,000 people to just about 90,000. So you can understand the tremendous impact this has had on people's lives. We got outdoor dining, which I'll talk a little bit about. We also had indoor dining, all of that reduced to a 25% occupancy, opened at the end of September. Because of outdoor dining and limited occupancy indoor dining, we hired back about 100,000 people, back to about 190,000 people. Remind you, that's down from 325,000 people pre-pandemic. Now, as you all know, indoor dining has again been shut down in New York City. We do not know when it's going to reopen or what has to happen for it to open in New York City. Although if you look around the state, indoor dining is open at 50% occupancy, where infection rate and hospitalization rates are much higher than they are here in New York City. So that's a whole other conversation about why places are open and we're shut. But it has a huge impact, obviously, on our industry and jobs here in the city. Because indoor dining was shut and the cold weather making outdoor dining less feasible for most people, we're starting to see the job numbers drop again, which is a huge area of concern. Financially, what this industry means, just the nightlife. And I'm just talking about restaurants, bars, and nightclubs and their related industries that operate from 6 p.m. to 6 a.m. was an annual economic impact of about $31 billion. So that doesn't even include all the food service in the morning and breakfast and lunch and in between. So it's an enormous economic impact to help fund all of our city services, everything from fire, police, and all the other services that we need to rely on, and also a huge driver of tourism, which is a multi-billion dollar driver for our industry. And so much is uncertain of when these people are going to be able to go back to work. When are the nearly 70 million annual tourists going to come back to our city to eat at our restaurants, drink at our bars, go visit our cultural institutions? So again, even more uncertainty. And if you look at just Midtown and Lower Manhattan, where they're heavy commercial districts, so some of the recent reports I've seen, less than 10% of office workers have returned. And you've heard big companies like Google and others that have said, workers don't even have to report back to the office until next summer. And who knows what's going to happen then, and who knows how many people end up working remotely. So all of these factors are really going to play a huge factor into the recovery of the industry. But one of the things we did here at the Hospitality Alliance, because our role is really to fight around the clock for the industry. We're very involved both in city, state, and national politics. So we're able to enact some really important laws that are not going to save the industry individually or even collectively, but give them a fighting chance of survival. So early on, two things that were so important as it pertains to rent, because that is the largest fixed cost of a business. We got a law that was recently held up in courts, which many people thought it wouldn't be, but we knew it was, and it was, that suspends enforcement of personal liability or good guy guarantees in leases. The governor has continued to extend the eviction moratorium that's been in place, and we're looking for it to actually be strengthened. Third-party delivery companies like Grubhub and Seamless that charge these outstanding, outrageous rates, up to 30+% of each order from a restaurant, have been capped at no more than 5% for the transmission of the delivery and no more than an additional 15% if that third party is conducting the actual delivery of the food and beverage. The PPP, the Paycheck Protection Program, we were able to get some important changes made for our industry, which extended the kind of look back period, also allowed you to use a greater portion of that money for things like rent and utilities. You could use up to 40% and still have the loan be forgivable, whereas the initial version of the bill only allowed 25%. Suspended different fees and got the city to finally focus on, although I know inspections are very frustrating from the city perspective, issuing fines and warnings before they just issue fines or suspend permits. We got the outdoor dining program rolled out, which we advocated for, that more than 11,000, or I should say, or about 11,000 of the restaurants are participating, which is, again, an enormous number. But to put in perspective, it's still only about 40% of the total number of eating and drinking establishments in the city. But it became so popular and such a lifeline because it not only allowed restaurants to hire places back, get some cash flow into the business, but it brought back a energy and a vitality and a vibrancy to the city streets, which was so critically important after we had been in lockdown for so many months. And it became so popular that the city council and the mayor had announced that the program is going to be made permanent. And that's a version of allowing us to take this crisis, and I use the Winston Churchill quote, "Never let a good crisis go to waste," and really reimagining New York City, reinvigorating our streetscape and how New Yorkers and our small businesses and our visitors interact with that streetscape. And that outdoor dining program is really such a bedrock part of the support and the recovery. And then just to kind of wind things down, we had been fighting around the clock for more federal support. It's disgraceful, it's shameful, it's every horrible word I can think of that the federal government has failed over and over again to provide adequate support to these business owners. We're not asking for a bailout. A bailout implies that our businesses did something wrong, when in fact it's the opposite. We did everything right. We were shut down by government. We've invested countless hours and money into ensuring high food safety standards and high safety precautions related to COVID to keep our customers and workers safe. We fed the hungry, we fed the frontline workers, and we've done so much to support that we just need support now back from our government, and they have failed over and over again. We are hoping to get a bill called the Restaurants Act passed, which had bipartisan support. It was a $120 billion revitalization fund that would give restaurants and bars the difference between their 2019 and 2020 projected revenues to pay for rent, utilities, payroll, vendor expenses, because we are part of the economic ecosystem that relies on a vibrant hospitality industry for their livelihoods. Think about the upstate farmer or the florist, the linen supplier, the sales rep that sells you wine and beer. They all rely on our industry. Unfortunately, even though it passed the House of Representatives, had about 53 sponsors in the Senate, the bill did not pass in this last round of stimulus. We did get more PPP, more paycheck protection money. For restaurants, it'll be a little bit better. Instead of 2.5 times your monthly payroll, you'll get 3.5 times your monthly payroll, and there'll be some more flexibility in how you use the money. A lot of the questions I know people have, we're still waiting for them to be released, but we have support from our US Senator Schumer, our congressional delegation, that when the Biden administration takes office, they will continue to push to pass the Restaurants Act, because that is the customized support our industry needs to really stand a chance of survival. And hopefully this PPP is just a bridge there. So I'll leave it at that and say that I hope that this conversation that follows is really a bridge for all of you to learn what type of policies and programs and support are out there to help your business, help yourself during these really trying times. So I want to thank you all for tuning in. I want to thank all of our partners for presenting today, and stay safe, stay strong. It's going to be a tough few months, but let's make 2021 a better year than 2020. And the one thing I know is that this industry, restaurants, nightlife, you got to be tough. It's in your DNA. So we're survivors in this industry. We'll keep fighting. We'll keep fighting to come out on the other side of this. And really the question now is, how can we mitigate the damage, mitigate the loss, and provide as much support as possible to our industry throughout the trying times? And you have my commitment that the New York City Hospitality Alliance will not forget about you, will not stop fighting for our industry. And we just greatly appreciate, your support, your involvement, your engagement, but really just the friendships that we've built with so many of you in the industry. So thanks so much, and enjoy the rest of the conversation, and hope you find it useful. Peace.
Andrew, thank you so much, Andrew. That was a wonderful overview, and that set us up perfectly for this conversation. I'm really excited to invite our panelists out. We have a wonderful panel: Robert Iamazzo, Managing Director for Traxy; Carolyn D. Richmond, co-chair of Fox Rothschild LLP's Hospitality Practice Group and Labor Council of the New York City Hospitality Alliance; Mark Hall, Esquire, partner of Fox Rothschild. And I'm also going to bring on our moderator, award-winning journalist, Brad Hamilton, who's also the founder and editor for the Hatch Institute. And Brad, I will hand it over to you.
Excellent. Thank you so much, Rivka, and welcome to everyone. Hoping that this is a really useful event. We are hyper-focused on, as Andrew said, customized support for the industry. And of course, one of the tools that is so useful for this industry is this relatively new element of bankruptcy law, Chapter 5. So subchapter 5. So that's the focus of today's discussion, subchapter 5 of the bankruptcy law. And it's really an amazing and helpful tool. So we're going to get into this, and we're going to discuss how it can be useful to you as an individual business owner. And fortunately, we have this great group of panelists who can help us get familiar with what exactly subchapter 5 is and how it can be useful. So I'd like to start by just asking Robert, who's a lawyer who's handled this sort of thing and knows a lot about it. And I wondered if you could just give us a little overview, Robert, of what exactly is subchapter 5 and how can it be useful to the business?
Sure. Thank you, Brad. As a business advisor to restaurants, bankruptcy has always been something that we would recommend they stay away from, because usually you can negotiate with your various stakeholders to avoid filing a bankruptcy. However, sometimes the inevitable is there, and that is there's no other way out to restructure your business. So subchapter 5 is relatively new. It used to be where $2 million in debt was the qualification. That has been raised now to any entity that has $7.5 million in debt can take advantage of filing a subchapter 5. It's important to note the differences between the Chapter 11 filing and the Subchapter 5. And the Chapter 11 filing is something that has been a useful tool if an entity wanted to sell its business, but where an owner wants to continue as an owner, he now can take advantage of using the Subchapter 5. And that is one key difference between the Chapter 11 and a Subchapter 5, in that the owner will retain their equity position without having to increase and adding more equity into it to keep that position. So it's important to understand that you will keep your business. It also is important distinction between a Chapter 11 is that unlike a Chapter 11, where a creditors committee will be formed to assess the plan that's going to be put forth, in a Subchapter 5, there is no creditors committee. You have a separate trustee that is appointed, and Mark Hall, who's with us, will speak to that a little bit later. And this trustee, I view that role as the traffic cop. The trustee is the one who will evaluate the business plan that will be put forth to see whether or not it makes sense and does not have to go and get the concurrence of all the creditors. So that's a very big difference, in that you don't have a creditors committee that will be looking over the shoulder and can object to the plan. It also is very from a cost standpoint, is not as anywhere near expensive as filing a Chapter 11, whereby you do have professionals from your lawyers representing the owner, the debtor, a financial advisor. You have a creditors committee, and a financial advisor to that creditors committee, and it's a long process and it's a costly process. The Subchapter 5 allows a business owner to file the Subchapter 5, and in theory, it's supposed to be an accelerated in and out process. And again, Mark could speak to that shortly. And the goal is to try and actually get in and out in 90 days. That means putting forth a plan that the trustee would recommend to the judge to approve. And the biggest difference, in my opinion, is that when you consider filing a Chapter 11, obviously you're worrying about losing your ownership, but more importantly, you need to be able to show the benefit of staying in business, of coming out of the Chapter 11. You have the same concern with the Subchapter 5, but the difference is you can put together a financial projection over the next 3 years as to how much cash you think you will be able to generate to be able to pay down your creditors. So if in fact you have $7.5 million in debt and you have $2 million in assets, in fact, in a restaurant, your real asset is very minimal, in that it's mostly equipment, which has very little value after you buy it. So that difference between whatever you have as an asset value, and what you owe will basically go away. You're going to have to show how you can pay down those creditors. So in my case, the example, if you had $2 million in assets and $7.5 million in debt, you've got to pay down $2 million over a 3-year period. And that is based on a financial projection. So if in fact you meet those projections, you can come out of the bankruptcy in this example and shed $5.5 million worth of debt and continue to own your business. And again,
so it sounds like, Robert, what you're talking about basically is this is a fantastic option for people who are worried about debt. They have a lot of debt. They want to figure out how to handle that debt. But instead of having someone else dictate the terms, you yourself as the business owner are actually putting forth a plan. You're going through your numbers, you're figuring out what you can handle, and you're submitting that plan based on your future projections and your current debt, just to handle these debts in a way that you can manage it, rather than having someone dictate to you what you're going to do and take away your ownership. Is that what you're saying?
That's correct. There are a couple of things, though, that need to be considered when you look at a subchapter 5 that are not any different than a subchapter than a chapter 11, and that is dealing with your landlords. Andrew indicated earlier that there are these good guy guarantees and personal guarantees that have been put on hold. But as an owner, if you have personally guaranteed bank debt or personally guaranteed equipment debt, and if you have personally guaranteed landlord, you still have to deal with those. That does not go away whether you file a chapter 11 or whether you file a subchapter 5. So anyone who is sitting there with personal guarantees on with their landlord or with equipment or banks, those will still have to be negotiated, because those do not get erased inside the bankruptcy. And also, Carolyn will speak later on, you may, as an owner, have unpaid wages. You may have some state tax issues and other tax issues. Those too go to you personally and do not go away. So there are things that don't go away in a subchapter 5 that are similar to an 11, but nevertheless, you will have a lot of leverage to help negotiate with those particular landlords and vendors to try and resolve those issues.
Yeah, and that's really important, I think, because in the discussions that have been occurring about subchapter 5, one of the big elements is this leverage element. I think a lot of owners are feeling under the gun. They have debt. They don't feel like they have any leverage at all. They owe money to different people. They owe money to the landlord. They may have equipment leases. They may have back payroll that they have to meet. And they feel like they don't have any advantages. But can you speak for a little bit about the actual specific leverage, if you will, the advantage that accrues to you when you pursue a subchapter 5 filing?
Sure. One of the things we do as business advisors to companies that find themselves with financial problems is to reach out to the various creditors and explain to them that if they work with us, they will have a benefit of getting something as compared to perhaps getting nothing, which is, the threat of the bankruptcy. With the subchapter 5, it's going to require more education with the vendors and the stakeholders. And in my personal dealings with landlords, they understand the bankruptcy world. They understand that regardless of whether you file a subchapter 5 or a subchapter 11, their rent goes into an unsecured pool. And there's a calculation you go through, but it's basically a year's worth of rent that becomes unsecured if in fact they don't work with you to try and renew a lease, to try and mitigate some of the past rent, add it on to the back. So it does provide good leverage in terms of negotiation. And also with vendors, most vendors to the hospitality world want to continue doing business with these customers, their restaurant owners. They're not looking to sever the ties. So it's a matter of approaching things on a reasonable basis and not using a hammer to use as leverage.
Excellent.
Mark,
Mark, maybe you can give us an example of, like, Mark has been dealing with this with clients, actually helping them sort through their issues, their debt, how to restructure, how to come up with a plan. Maybe you give us an example of a real life example of a bar or a restaurant that's dealing with this issue right now.
Certainly, Brad, and Happy New Year to everybody. Good to be here today. Thank you for having this important webinar. In terms of a real world example, I can tell you that I am what's called a private trustee in the subchapter 5 world. There are several of us in each jurisdiction, and I am one of the 10 in New Jersey. And with that, we each get assigned to different cases as the subchapter 5 bankruptcies are filed. And several of my cases that have been filed so far are restaurant cases. So I've been able to see, like, on the ground what debtors are attempting to do as they negotiate with a landlord, for instance, or a secured creditor once a subchapter 5 bankruptcy is filed. So to the point about a real world example, I would like to get into some details in a few minutes, but I want to go back and just kind of talk about the overarching concepts too, because I think that's an important I think it's important to understand that before we delve into too many details. As part of that, I just want to highlight a couple things. Robert, first of all, did a great job with an overview of what subchapter 5 is all about. Now, I can tell you in my 25 years in this industry, bankruptcy has always had a stigma attached to it. And it predates that as well. And there are a lot of restaurant owners, a lot of business owners that would never consider bankruptcy. And this is a unique point in time in our history of the country, in that you now have a situation where there should be no stigma attached to a restructuring under bankruptcy. We are obviously dealing with unprecedented times in the last century, where nobody is at fault for doing anything wrong in terms of mismanaging their business or making mistakes along the way, which would lead to a potential bankruptcy. I mean, we are obviously dealing with a situation where the government has taken health considerations into effect, of course, or into consideration, has decided that this is what's best for our society, which means what do we all do, though, to survive this economically? And as business owners, you now have this incredibly unique opportunity that Congress, most people don't accuse Congress of being prescient often, but I think you can here in this case, because last summer they passed this law, which went into effect in February of 2020. And that law allows small business debtors to reorganize under the subchapter 5 in a way that they couldn't before. And the pandemic situation, I think, absolves individual business owners from being in any way attached to a stigma for filing a Chapter 11. Importantly, a couple of things I just wanted to kind of highlight or go over what Robert said. I wanted to kind of draw a couple of things out that I think is important to know. He talked about a cap of $7.5 million for your of debt for your business, and that is true. If you're a small business debtor, meaning that if your debt does not exceed $7.5 million, which includes both secured and unsecured debt, then you can qualify as a small business debtor, at least until March 27th, which is when the CARES Act increased the debt to. Now, we're hopeful, all of us in this industry, I think, are hopeful that Congress extends that deadline, because I think this is a useful tool for small business debtors. But in the meantime, it will sunset on March 27th of 2021. But that debt does not include certain kinds of debt. So let's just say you're a restaurant owner and you say, oh, I owe $10 million or $15 million. I don't think this is, obviously this isn't for me. There's a couple of important caveats. If you have insider debt, if you owe money to an insider, which means family member, affiliate of the restaurant, anybody else that is considered close to the restaurant, and there are some legal nuances to it that may come into play, like in ways that surprise you. But the reality is that if someone close to the business, an insider, that debt is not counted towards the threshold. And in fact, as a real quick example, there's a luxury goods manufacturer, Furla, which is an Italian company, that filed for bankruptcy in New York. the Southern District of New York recently, a few months ago. And Furla is maybe known to some folks on the call or on this webinar. It's a luxury brand that has an Italian parent, and they were able to file for bankruptcy under Subchapter 5, because even though they're a large company, a significant portion of their debt was to an insider, to its parent company. And when that is the case, then you can still take advantage of Subchapter 5, even if your total debt might have been $40 million, but only a portion, something under 7.5 was owed to non-insiders. Another significant thing to consider is contingent debt. If your debt is not proved, if someone just says, they owe $10 million, let's say someone files a lawsuit against you, and they allege that you owe them $10 million, $5 million for some slip and fall or some other liability associated with your place of business, but it's not proven yet. That's what's called a contingent debt, which means you don't owe it yet, and you would dispute it, or because it's contingent. So that does not count towards your cap. So it's a couple important factors, I think, in terms of understanding if your business would be eligible for Subchapter 5. And a couple more points I just wanted to highlight, like the idea of why you can retain your equity now, whereas in a Subchapter 5, whereas it's very difficult to do so in a regular Chapter 11, is because you don't have to have what's a separate cash infusion to essentially pay all of your unsecured creditors 100 cents on the dollar. You essentially have this right to kind of ride roughshod over them, as long as you can show that your plan is fair and equitable. And fair and equitable means that you can show the court, you can prove to the judge and to all the constituents in the case that you are using all of your disposable income, which means once you pay your bills, once you pay all your employees, your rent, everything else, what do you have left? So under this 3-year plan that Robert talked about, what do you have left to pay your creditors? Let's say you only have 4% of your revenue left over to pay creditors. That's all you have to put towards a plan to pay off those creditors over the next 3 to 5 years under a plan in Subchapter 5. So it really makes it an affordable option for small business debtors, because you get to keep the equity in your restaurant, which I'm sure some of you have poured blood, sweat, and tears, all of you have, for many years, decades, and you get a chance to keep that and only pay back your creditors a small percentage, and they really can't do a whole lot to stop you, as long as you are putting into the plan this excess amount of income, which is called projected disposable income. And disposable is deemed to be something above and beyond what you need to pay to operate your business. So those are just some important things I thought that I wanted to hit on, and after hearing Robert talk about kind of the general themes.
Yeah, let me just jump in quickly, because I think that when people in this business think about debt, I mean, there's one debt that dominates the thought process, and that is what you owe in back rent to your landlord. This process that you guys are describing is basically a big financial reset, where everybody realizes, all these debtors realize they're not going to get paid back in full, but they're going to have to rely on your plan as the business owner to find ways to pay back some of that debt. Can you talk, Mark, for a little bit about how this particular filing under Subchapter 5 resets a business owner's relationship with the landlord, and specifically related to the common situation where someone owes a lot of rent, back rent?
Right, absolutely. So Robert touched on this before by saying that when you file for bankruptcy, and by the way, this happens when you file for Chapter 11 bankruptcy or this Subchapter 5 bankruptcy. The real difference is it was very difficult for a small business to afford a regular Chapter 11 for the reasons that Robert talked about. But when you file for bankruptcy, this reset occurs. And what happens is, if a landlord has, let's say 7 years left on your lease, and you think to yourself, well, I can't, how can I get out of this? I need to decrease my space size, or this isn't working out for me for a variety of reasons. Well, you can't really do a whole lot outside of a bankruptcy scenario, because you have your obligations under the lease and under state law. And if the landlord cannot mitigate its damages by reletting the premises to somebody else, which is obviously going to be more challenging now than ever before, or certainly in a long time, then you are stuck with whatever's owed under the remainder of the lease. The difference is in a Chapter 11 bankruptcy, and in subchapter 5 in particular, the landlord's damages are capped at 1 year's of worth of rent. And not only are they capped at 1 year's worth of rent, but then they slide into this bucket of unsecured creditors. And Robert talked about this. And it gets lumped into the other creditors that are part of who you owe money to. So all the vendors or anybody else who's owed money, for the most part, are considered unsecured creditors, unless it's a bank, you owe who's secured, or there are a few other exceptions like taxes. Those are priority unsecured, but the general unsecured claims would be where the landlord falls. And now the landlord doesn't necessarily want to be there. The landlord doesn't want to receive a cap, and the landlord doesn't want to necessarily have the risk of you rejecting that lease in a bankruptcy. One other powerful thing you can do is you can say, you know what, there's a lot of spaces available in New York City right now. There's a lot of landlords struggling with a lot of tenants. I'm going to go elsewhere. This landlord's not willing to play ball. This landlord's not willing to be reasonable with me. I'm going to file for bankruptcy. I'm going to reject my lease, and my damages will be limited, and then I can look elsewhere. Or I can at least threaten that I can reject the lease, because that's a tool that you have in a bankruptcy. And as part of that, you might prefer to stay in your premises, but you didn't have the leverage in order to get the landlord to come to better terms, more reasonable terms, maybe shorten the lease, do some kind of hybrid formula of gross sales would be the indicator for your rent, as opposed to a different base rent lease, which is probably what most people have now. So yeah, there's bankruptcy tool opens up a lot of possibilities. And by way of example, we talked about this, Brad, you mentioned before, Brad, that, give some real world examples. One example, I am a trustee in a case in northern New Jersey, and the landlord is the largest creditor by far. The landlord isn't just a landlord. The landlord is also the entity that sold a liquor license to the restaurant owner and has a special member interest in the restaurant, a non-voting interest. And as part of that, the landlord said to the restaurant owner, well, I'm as a special member interest holder, I'm going to block you from filing for bankruptcy because I have to vote to approve it in order for you to file for bankruptcy. The restaurant owner said, I don't think that's right. I think you're wrong under the law. By the way, it's not an easy call. It depends on the facts of the case. The restaurant owner filed for bankruptcy, used the leverage of the case to renegotiate with the landlord, who essentially was not moving at all, like one iota, from his strong position, and was able to get to the drawing board with my help as a negotiator, a facilitator. And I was able to help the debtor. And frankly, the parties did a lot of work on their own. My role was fairly limited, but at the same time, the fact that I existed, the fact that a bankruptcy existed, did a lot to create the leverage in favor of the debtor, in favor of the restaurant owner, to allow him to renegotiate with his landlord and get out of the terms of what was there. And in this particular case, it's going to lead to a liquidation. But as an equity owner, they're going to get some equity back that they put into the restaurant. It doesn't all go to the landlord, which is what the threat was. So a liquidation is not ideal, but at the same time, it happens, and it's a better outcome where you have some return on your investment than you would have otherwise.
It sort of sounds like what we're talking about is this is an opportunity for you to shed a tremendous amount of debt, restructure, but also at the same time, these creditors are essentially becoming financially invested in the future of the business. In other words, you're submitting as a business owner a plan. This is how we're restructuring. This is how we're going to handle our debt. But for these debtors to get paid back something, your business has to succeed. So the plan has to be reasonable. And it sounds like the business owner has to really work hard to sort of figure out exactly what they can afford, the issue of debt to annual revenue, that kind of thing. You have to think really hard about what you can afford, what your revenue is going to be, which is still uncertain. Obviously, we don't know exactly what forward revenue is going to look like for this industry. But it sounds like the main advantage is that not only are you restructuring so that you're basically saving a huge amount on the debt that you owe, but you're also coming up with a plan for survival that makes a partner of your landlord, of your equipment leaser, of other people that you might owe money to. Is that an accurate assessment?
Yeah, it's very well put, Brad. Look, this is not something that anybody really wants to do. No business owner wants to file for bankruptcy, even though the stigma of bankruptcy perhaps no longer exists because we're in the wake of a pandemic. Nobody wants to do it. It's something, though, that does offer that reset if you do it. And now is really an amazingly unique time in the history of our laws, our bankruptcy laws, which makes this a real feasible opportunity for small business owners. There's been thousands of business owners across the country who have taken advantage of this. And frankly, most of them have come out and have reorganized and restructured their business, as Brad mentioned. And so there's been a lot of success. And one other point I want to make generally is that the bankruptcy courts, the judges across the nation, want this to work. The U.S. Trustee's Office, which is a branch of the Department of Justice, which oversees the program in a way, they want this to work. They want debtors to succeed. Now, that doesn't mean that the system is stacked against creditors, but it's certainly, there is some favor to debtors in that people want to see this work, especially for small business owners who are truly the backbone of our economic society.
I want to jump in and add a little bit of a but, because I agree, Mark, with everything you've said. And I think it's certainly very important to realize that stigma that a year ago we would have seen is really gone. I haven't really heard the concern anymore that what will this look like, because the whole country is in a panic. But there's one other cost that I think we can't underestimate. And I'm a labor lawyer, so this is going to be employment related. We've handled, it's hard to believe, but probably over 700 wage and hour actions in the last 12 years in New York City alone. There is not a restaurant in the state of New York, California, probably the same, Florida, Massachusetts, that doesn't have wage and hour liability and significant liability to their employees. New York happens to have the longest statute of limitations for a wage claim of 6 years. And you sort of get outside of bankruptcy with this problem, because personal guarantees, as Robert referred to, there are personal guarantees signed on the vast majority of these settlement agreements of a wage claim in the last few years. And that's largely because there's also individual liability under the wage and hour laws. So when you're talking about a small business, and I'm sure we'll give more examples later, rent is obviously the big thing. It's due every month, and that is a huge debt. But there are an astronomical amount of pending settlements that get paid out over a year, 2, 3 years. And even for a small single restaurant, you have settlements of $1.5 million, $2 million. First, you have your owners and managers who have often signed personal guarantees. And the second thing that I don't think enough people realize is that's great. Bankruptcy, you get a stay, litigation generally gets held. You don't have to incur those expenses necessarily. And I'll defer, Mark, to you as the expert. But with wage and hour law, plaintiff attorneys are very smart. And they don't just sue the corporation. They sue the named owner or CEO. And that exists outside of bankruptcy court. So to the extent the company may have a stay, that doesn't exist for the owner. It's joint and several liability. So over the last dozen years, as we've counseled restaurants who, quite frankly, didn't pay attention to wage and hour laws, how do you get out of it? The inevitable question every time is, well, what if I just file for bankruptcy? That does not necessarily discharge your wage and hour obligations, either under statute or, more importantly, through a lawsuit, because plaintiff counsels will just turn and sue the owner who's out there on social media with their yachts and their second, third, and fourth homes. And that becomes a bigger problem. So I don't know, Mark, how much that plays into your discussions over the past 6 months with businesses like restaurants, but that's always a liability that I'm very worried about.
And what about payroll debt, just existing debt that a business might have to managers, employees, people that have, maybe some of them had contracts, maybe in some cases you have union workers. How does subchapter 5 affect that type of debt?
Well, I'll start first. Most of the restaurant industry does not have unionized workers. So for starters, we're pretty lucky when it comes to dealing with pensions and that kind. But the priority issue, which I'll defer to Mark, but you have administrative expenses first. So those salaries and wages and commissions that are earned, essentially, Mark, it's after the filing period, those will have priority, correct?
Yeah, it's some of the, I don't want to get tripped up on the words because they're not important. There's a bankruptcy vernacular, which I won't bore everyone with, but the basic way to remember it is everything you do post petition. So you file for bankruptcy, let's say January 15th. Everything that you would otherwise be due January 16th and beyond needs to be paid in the ordinary course. So you can call it whatever you want to call it, but it needs to be paid. It doesn't stop those liabilities from accruing as your ongoing business. The wages, so there's different buckets. So the wages bucket is something that does have what they call a priority unsecured claim, which means they come ahead of general unsecured claims in terms of the payment structure. And the bankruptcy code, which are the law passed by Congress that oversees all of bankruptcy, that allows for a priority claim for employees of 13,600, and for monies that were owed over the past like 6 months, I believe. That could be severance, it could be vacation pay, it could be regular pay. So those buckets, like when you talk about employees, there is a pre-petition, like the amount that's owed to employees prior to bankruptcy gets a bit of an elevation, and those have to be dealt with in the bankruptcy case. So which means that those employees will get paid. If they're owed money, they'll get paid in the special priority bucket after the filing.
I would probably add to that, Mark. That's very helpful. And again, I'm not the bankruptcy attorney, but you're also looking at the statute of limitations. And as I said, in New York, it's 6 years to pursue a wage claim. Federal law, it's 2, potentially 3. And every other state in the country is some number under state law less than 6. So it is very helpful to the extent that you have priority, obviously, for what comes now. The 180 days, I think that's what the statute talks about for the look back. That's really helpful when you have 6 years of outstanding wages potentially that are owed. Plaintiff lawyers are just getting very smart though, and I'm getting calls all the time. They're reading the newspapers, they're reading the filings, and they're paying a lot more attention to what the owners have and whether they can get that money for that back period, really 5.5 years potentially. And if you can do that, that's great. If you can't, the plaintiff's bar may look the other way and just simply say it's not worth going after an owner or a manager, as that's defined under the statute for the wages. But it's something that's potentially a big deal because you think that it's a panacea with bankruptcy, but it may not, depending on how you're structured and who's making decisions.
I think one thing that I'd like, and maybe Robert, you can jump in on this. One thing I'd like to give the participants a sense of is, what is a reasonable amount? I mean, when you're talking about, a Chapter 11 or liquidation, these debtors know they're going to get, pennies on the dollar because there is no real asset. And in fact, now many of these bars and restaurants that are struggling, I mean, their assets are practically nil. I mean, they have some equipment that's worth, a small fraction of what they paid for. The lease may not be any value at all because everybody's having vacancies. So what advantage, what financial asset is there in a lease that may be, slightly under market and you get 10 more years on it? So it's not like these places have much in the way of assets. However, in the negotiating part of this, where you're coming up with a plan for your business, you do have to take into consideration some general parameters of what kind of cents on the dollar will make sense and will be acceptable to the bankruptcy courts when you file under subchapter 5.
Mm-hmm. Yeah, I think a couple of points to Carolyn, to Mark's points. When you have labor issues, generally they go to the owners, to the stakeholders. And in fact, when you have tax issues, they also can go to the CFO who's signed the checks in the past to pay payroll taxes. So they do not go away regardless of whether you file a subchapter 5 or a chapter 11. They have to be dealt with, right? And recently, I had a catering company that had labor issues, and we ended up coming to a settlement with the plaintiff's counsel because of the fact we were threatening, look, we're going to file, and if you want to go after, in this particular case, was an owner who was health-wise not doing well and didn't have a large estate that they can continue to go after, we were able to negotiate what I believe was a reasonable settlement. So you cannot ignore, as a business owner, where you have personally guaranteed a debt, or whether you have labor-related open issues that go to you personally, it comes down to really negotiating them and using the bankruptcy as helpful leverage to do that.
And can you give us a sense of what kind of savings owners are finding with the either the threat of or the actual filing under subchapter 5? What kind of I mean, all business owners in this industry are really, focused on what's the bottom line? What kind of expectation is going to be made of me to satisfy the debt? What percentage of this debt do you think is reasonable for me to try to manage over the next few years of my business? That kind of thing.
I think wage and hour is a little bit different than anything else. The example Robert's giving is probably one of the most common, and if it's a catering company, it was more than likely a service charge claim. And let's just say roughly, if you're dealing with the risk of 20% of your catering sales having to be paid back over the last 6 years, it's several $1 million even for the smallest of businesses. You do have leverage, as Robert said, in the negotiations and use the threat of bankruptcy. We've actually used that a number of times this past year to renegotiate settlements that were even already approved by the court. And it's on the plaintiff to decide how much risk at this point they want to take. The court ultimately does have to approve these changes in these settlements. But one of the biggest issues, and we had a $4.3 million catering type of settlement earlier this year. I think it was last February. We settled for 4.3. The risk was something like $11 million. Obviously, about 3 weeks after we agreed in February, the world just completely stopped. We spent the next 6 months renegotiating with the plaintiff's counsel and got $1 million off that settlement, which was incredibly good. However, what did we have to do to get that? We had to show the personal finances, tax returns, everything under the sun of those owners, that executive chef, his partners. And that was a big deal, because before you can get a discount of 50, 60, 70% off, maybe even more, which is possible, you need to you need to be able to prove to the court that this was a reasonable settlement and that the reduction was necessitated by the financial conditions.
Right. So you're saying basically you had an $11 million debt that came down to $3 million, roughly in that range, but you had a lot of work to go through. And I think that's also part of it, is that the people here who are listening to this and considering this option of subchapter 5, they have to understand that there is work to be done in terms of going through the debt, making a financial plan, having somebody on your side, whether it's a business reorganization, whether it's a company that handles business reorganization, or attorneys, or both, to help you figure out, first of all, how to file and how to make a successful claim, so that you're meeting the expectations of the bankruptcy court, but you're also then taking advantage of these tremendous percentages off on your debt. Is that accurate?
And I think, Brad, it's important to note that if a restaurant owner has not had any claims made to date, in other words, if they're considering going into a bankruptcy and there have been no claims made by any of their employees or any of the state jurisdictions or anything of that nature, that will actually psychologically help him or her if they go into a bankruptcy to deal with these issues that come up. It'll provide you more leverage. If the claims have been made prior to it, then you're going to have to put that into the mix as to how you deal with those. Right. But I'd like to just shift to one thing we've more than likely our restaurateurs have is secured bank debt, and I would like to talk about that, because when you look at the difference between subchapter 5 and subchapter 11, secured lenders usually are the 800-pound gorilla in the room. They're usually the ones who drive what's going on in the bankruptcy. That leverage really is curtailed tremendously in a subchapter 5, because now you may owe a bank $3 million. And again, I'm going to set the personal guarantee aside, which is not something we probably should, because most restaurateurs, if they're borrowing money of that kind of dollars, they're more than likely do have a personal guarantee that they have to deal with. But if they don't, they have tremendous leverage in a subchapter 5, because now all that excess debt, that is the amount between what the asset value is and the amount of that debt, all becomes unsecured, all goes into that pot that gets split up among everybody.
Interesting.
But even if you have the personal guarantee, lenders, unless you're really a bad person and have been squirreling the money away over in the Bahamas, lenders generally don't want to go dealing with that if they don't have to. You usually can negotiate all of that.
Exactly.
Whether you're in or out of it.
Well, one thing I think people might want to know a little bit about is, if you can answer this sort of quickly, because we're running out of time on our event here, but the actual technical side of it, the cost of filing under subchapter 5 versus chapter 11, how long does it take? Can you give some basic ideas of the technical side of going through the process?
Well, there's a theoretical and then there's a practical. Most professionals, business advisors like myself, Mark, as a lawyer, when you get that question in the chapter 11G, what will your fees be? It's like, oh my God, it depends on how complicated all things happen in the chapter 11. So it's very difficult to come up with that number. In the subchapter 5, though, Brad, the theory is that you're in and out quicker than you would be, and you don't have all these committees that you have to deal with. So it's supposed to be considerably less. And if I had to throw a number out, I think, if you looked at the complications, if the business advisor and your lawyer sat down with you and looked at all the issues that you had to deal with, whether, like Karen said, you had wage issues, whether you got bank issues, that's going to impact it, because the things that have to get done is a financial advisor has to put together with the owner, the business plan, the cash flow projections. That's something that you can pretty much fix a price on, maybe $30,000. Okay. I don't know. I'll let Mark speak to the legal side, but I guess in theory, if you put a ballpark of $100,000 out there as compared to several $100,000 in an 11 is kind of what I would say. It's difficult to get a professional to actually give that number, but I think a range, and I'll let Mark, through his experience, talk more to that.
Yeah, sure. I'll jump in, Robert. You're absolutely right. There's some more certainty in the subchapter 5 world, although it really does depend on the case, the complexity of the case. We at Fox Rothschild, we developed a flat fee arrangement that we are offering to the right type of debtor, the right type of business owner, and that number, there's a range to it, but depends on the size and the complexity of it. But that provides even more certainty So what we do is we meet with the business owner and we say, we have a consultation. We talk about whether or not this makes sense, because if you're not able to save way more money than you spend, it's not worth it. So we'd have to be able to advise the business owner, does this make sense for you and your business? And the savings that you would accrue from it, are in this range. And then the cost for services are, another dollar amount. And what we try to do is offer that flat fee arrangement, so that upfront, after we have that consultation, and we can look into the size of the case, the complexity of the case, and we can offer that to them. So that's even more certainty. And then the process goes from there. And if we're willing, because we're willing to do that, we're willing to take a little risk along with the business owner, that even if it gets more complex than anticipated, that we're along for the ride, and we are there to provide the necessary services. But it depends.
One question that has come up, and I think we sort of need to transition now to some of the Q&As that have been, the queues that have been coming through. Some people have asked some questions specifically. One of them is about whether the owner of a business can include in the business plan salary for him or herself. I'm assuming that is not an unreasonable request to fold into a business projection.
Right, absolutely not. Yeah, that's part of project disposable income, as that is defined in the bankruptcy code, should absolutely include monies for an owner. I mean, an active owner. Absolutely.
As long as it's reasonable, Brad. I think, if an owner was pulling out $300,000 a year in salary, and given circumstances, where they are now, I think that would be not acceptable to put something like that in there.
I don't know if Mark, maybe you want to address the fraudulent conveyance issue, because that comes up a lot when I have very creative clients either trying to get out of settlements or exactly that, thinking about bankruptcy and whether they should move assets to their spouse or pay the spouse. And the truth is, we're dealing with small businesses, and as much as we kind of cackle, like, of course you can't do that, not every business person understands that concept. And I think that might be helpful if you can explain a bit.
Sure. Yeah. I mean, it's an important topic, and it's worthy of its own webinar in of itself. It's complex, but the concept is that if you transfer property prior to a bankruptcy filing, and under the bankruptcy code, it's within 2 years prior to the bankruptcy filing. But under state law, it could be longer, 4 or 6 are most common statutes under state law. So if you transfer valuable assets without consideration, so if you essentially just give stuff away because you're looking to protect those assets from creditors obtaining access to them, then you are in danger of having somebody come along in the bankruptcy process and ask for that money back to the person who received it. So the transferee, the entity or person who received the money, let's say it was 9 months prior to the bankruptcy, if there wasn't actual consideration, real valuable consideration given for that transfer, then there is a very real chance that could get clawed back. So that's part of what we do when we consider what makes sense for a business. Those are some of the preliminary questions, because clearly everyone needs to be aware of what's at risk if you do in fact file, and that could be one thing that is at risk.
Interesting. We have a couple of questions that relate to the relationship between the business and the landlord. There's one that there's a person who's asked about good guy guarantees and how that might affect the process, and another person who is in the process of negotiating, and yet another person with a landlord, and then yet another person who is having some trouble with the landlord, who's unresponsive and not open to negotiation. Can you give us some perspective on sort of like where that is? What kind of personal guarantees might play into the factor? But I think the idea here is that there's a lot of interest in learning more about what's the starting point to negotiation with the landlord. How do you handle these good guy guarantees? That kind of thing.
Sure, I'll jump in. The good guy guarantees, generally the ones that I've seen are usually 3 to 6 months worth of the past rent has to be paid, and then they're able to get out of the leave the place broom swept, and you can get out of the get out of the rest of the term of the lease. And as Andrew said earlier, in New York State, there's a moratorium in place right now where landlords cannot conduct evictions and cannot sue under personal guarantees at this point. Now, I don't know when that will expire, but right now that is still in place. So it certainly helps you, should help you in your negotiation with the landlord. I've just negotiated with 4 landlords in New York, and it turns out that my client had to go into a liquidation, and the landlords, every one of them accepted what we had in a security deposit, whether it was an LC or a cash security deposit. Only one, we had to go a little bit higher than that, but the New York landlords understand that they're in a predicament. And as far as the landlord that is not willing to come to the table, then it really requires, what does that owner want to do? Do they want to stay where they are? Do they want to move? Like Mark said, there's plenty of space they could move to, but again, it requires money to probably outfit it and things like that. But I do think there are ways to get that landlord to the table. And the threat of bankruptcy is certainly one of them.
Well, they understand that if you file under Chapter 11, the chance that they're going to get paid, back rent is minimal. I mean, they might make something back, but I think the idea behind Subchapter 5 is to invest the landlord in the future growth of the business, the success of the business, so that they'll get paid back more than they would get paid if there were a liquidation or a Chapter 11. Is that accurate?
Well, even Chapter 5, I mean, if you file a Subchapter 5, it's the same rules that apply as a Chapter 11 or Subchapter 5 as it relates to the landlord. That 1 year's worth of rent is unsecured, and it gets paid out with all the other unsecureds, whatever that percentage would be. But you won't be staying in that space if, in fact, that's what you do. Or if you want to stay there, it comes down to negotiation. And I think I've seen, and Mark could address this too, there are landlords who are, I always commented, when you look at metrics, if you're paying more than 10% of your revenues to your landlord, then your landlord's truly your partner. And I think what's coming to fruition is landlords are now saying, okay, some of that past rent will add on to the back of the lease, we'll reduce the lease payments. How about if we profit share a little bit with some of the monies that you're going to be going forward to pay down some of that rent? I'll give you a lower rent if you do that for me. So there are lots of ways to skin the cat.
Yeah, Robert, I was going to just add, this is kind of a come to Jesus moment, for lack of a better expression, on so many bases, because I don't think we're going to be going back to the type of models for business, small business that we had before March. It's just that simple. And hospitality more so. And Subchapter 5 also requires you to really spend the time and see what is our future. Usually we have metrics, and I've been on the, as I say, the client side. I've been general counsel and an operator before, and you have an unbelievable amount of data that we always, send out to the lawyers and the financial people, and we can look year to date. Normally I could go back and say, January 3rd, what was the weather the past 10 years? How many sales did we have? Did we get to do any outdoor dining? And you knew what your inventory was. You knew your covers. You knew everything. We can't really use that to predict going forward right now. And we're starting to, there's been, I'd say, anecdotal comments about changing the model, but we're starting to see a lot of people saying, you know what, I don't need a storefront on 57th Street. I could use a second floor and have a restaurant, up there in the basement. I could do a ghost kitchen concept, and maybe the landlord can help us with a lease for space in Long Island City. We're looking at a lot of different ways to rebrand and reconceptualize, and that's something you need to spend time now and have a plan and an outline of what you might be able to do, because that's helpful when you're negotiating with landlords and lenders as well. No one wants to put bad money in right now.
Exactly. And then there are other options as well, like crowdfunding, for example. You can start to, rely on your fans, your super fans of your business to help you and with small to medium-sized donations, that
Could
kind of
do
thing.
that, but I think one of the biggest problems you'd hear from restaurateurs in the city is when they were starting out, they had 50 or 60 different partners and investors, and you kind of want to make that a lot smaller. Look at the actually not even the ghost kitchen, look at the food hall model. The last few years, we've had a lot more attention in food halls and quick casual, and we've been moving away somewhat from fine dining. I think we're going to start to see virtual food halls, which are kind of a combination ghost kitchen, where you can have multiple concepts that a customer can take out or deliver, and it's all coming from the same kitchen. It's about how you place yourself on social media, and that cuts down on an astronomical amount of labor as well. So you need to know what your future is.
Definitely. I'm sorry. We have a quick question. I wonder if I frankly, I'm not familiar with this type of loan, but someone is asking about an EIDL loan. Do you guys know what that is? You heard of that?
Yes. It was a state loan that was given. It was limited to a certain dollar amount, and I don't know if it falls into the same category as the PPP loans in terms of forgiveness. I believe it does, but I'm not an expert on it. I don't know, Mark, I see you shaking your head.
Yeah, sorry, I don't mean to visually jump in on that, but yeah, it was part of the CARES Act, right? And the idea is that it was available for like under the SBA, a different type of loan. The that wasn't those are sort of more in line with the typical SBA loan, but under the CARES Act, it provided a different tranche of funding. I think that I haven't heard personally of another round of EIDL loans, although maybe I've missed it. But the PPP loans that was just where you got the second round, I think that Andrew referred to it in his opening statements. Just a couple of days after Christmas, the Consolidated Appropriation Act was passed. And in that, you had some provisions that are important to our discussion today, including another round of PPP loans. And Andrew mentioned specifically that there's some provisions in there that affect restaurants in a positive way. For instance, you're allowed to borrow 3.5 times your monthly payroll amount, as opposed to other businesses are only allowed to borrow 2.5 times. One thing that's part of that act, the CAA, which I wanted to mention in the context of negotiations with landlords, is that they essentially, in layman's terms, you are now, if you file for subchapter 5, and it's specific to subchapter 5 bankruptcies, you are allowed to take your first 4 months of rent. If you can't pay your rent, or have trouble because of COVID restrictions, the first 4 months of rent after you file for bankruptcy are now essentially allowed to be put into a bucket and paid out over time throughout the plan. You still have to pay it in full because it will be post-petition rent, but you don't have to pay it right away. So yet another way to help small businesses restructure, because in a typical Chapter 11, there's a 2-month period where you get some leeway in paying your landlords, depending on how aggressive the landlord is. They may come after the rent right away, file a motion, try to make you pay it immediately. But there's usually a little bit of a window of time where bankruptcy courts give a debtor some chance to not pay rent right away. That usually lasts a month or two. Now you're talking about a 4-month period because of COVID, that small businesses that restructure under subchapter 5 can take those 4 months of rent and put them in a different bucket and pay out over 3 to 5 years. It just gives you a better chance to restructure.
Yeah, these are the details that really are so helpful when you're trying to figure out exactly what your plan of action is. But it sounds like also you shouldn't try to do this on your own. I mean, it's complicated enough that if you're considering this, you really need to weigh all your options, and you need help in terms of figuring out what kind of budget you can create, whether that includes PPP loan or not. I mean, it's sort of hard to know for sure now, like what kind of money might be able to come in from these government grant programs. But I think that it sounds like the individual business owner has to really think hard about what can that person afford, what kind of revenue are they likely to generate, once you get back to 50%, once you get back to full capacity, and when that might be. A difficult thing to project, of course, but I think for those people that are really just fretting over debt, this subchapter 5 is a godsend. Obviously, it's not just for bars and restaurants. Other small businesses can take advantage of that, but it does seem particularly helpful to this industry because of the specifics of what affects the financial side of bars and restaurants.
Look, nobody has margins like a restaurateur, and we were headed to doomsday going into 2020. To be honest, we were seeing far more issues with finances, the rent. I mean, everyone knows it's about the rent in New York and other issues, other cities. But this really, I hate to say the death knell, but it is, and you need to take advantage of those resources and experts you have. I know every penny counts in this industry, but we have experts like my partner, Mark and Robert, turnaround experts. There's all sorts of people out there, your accountants, who should be called in. We tend to have a bad habit in this industry for the small business of waiting until it's almost too late. And I've seen disasters where, I'll give you one example, little unrelated, but the mentality is just living to the moment. We had a restaurant that opened about 5 or 6 years ago, well-known chef, very well-known, very well thought of. And I had given a proposal. We have a flat rate, and in this case, I'll say what it was. It was about $5,000 at the time to do all the onboarding, all the payroll, everything we needed. And I vividly remember a conversation driving up Park Avenue where the client just told me, Carolyn, it's just too much. And I'm like, 5,000 now or 5 million later? And he's like, nope, can't do it. And I threw up my hands. What happened? I mean, and this is horrible. 4 years later, we got a suit. He had pulled documents from every friend in the industry, mainly mine, but they were 10 years old. And the debt was undeniable. The liability was significant, and he couldn't get out of it. He filed for personal bankruptcy. Partners didn't want to invest. And that's just stayed with me for a number of reasons. $5,000 to get the right advice were, against losing everything. And you've got to be able to think a little bit further than tomorrow.
And Brad, if I would just interject, I think if nothing more, if you walk away from this webinar with a lot of questions buzzing around in your head, I think the smart thing to do is, as Carolyn was saying, seek some professional advice. I know as far as I'm concerned, I'd be glad to jump on a call with anybody. There's not going to be a charge for that. I'm sure Mark would do the same thing, because you really need to understand, and Carolyn, you need to understand what are the issues that you as a business owner are dealing with, so that you can get some good advice as to, does this make sense for you, or are there alternatives that you should be thinking about ahead of time? Because I can tell you, if you have a feeling and a good feeling that COVID didn't destroy your business to the point of where it can't come back, where in fact you can resurrect, come back from, as the Phoenix says, you should think seriously about a subchapter 5. It's probably, in terms of investment of money, will be the best money you could spend to save your business and keep you as an owner. But before you get to that decision, I think you need to seek professional advice to understand what the issues are that you would have to deal with if you were to file, and are there ways to resolve it by not filing, because that's usually the best. But if you have to file, at least you have, I know it's still costly, but if you believe there is a business, unlike 11, you can come out of this by paying off these people a fraction of what they're owed and still have your business.
Yeah, exactly. You retain the ownership, and you're also, whatever plan is enacted is created by you, rather than having some other independent evaluator looking at your business and saying you have no assets, you owe all this debt, so liquidation, you're out of business. So it really is a matter of each individual owner saying, yes, I can move forward. I do think this is a business that will survive and can survive. But I need to be fully informed. And as you said, Robert, and I think has been mentioned a couple of times, merely the threat of filing particularly for landlords who know that this is out there, that provides the strategic advantage that might actually begin the process of figuring out how you can handle your back rent and move forward with a reasonable rent. I mean, it's rent really for a lot of places. It's just, how do I deal with the rent?
I think you also have to make sure you're looking at the stages. Right now, this is an emergency, and rent is certainly the biggest obstacle. And Robert and Mark and their colleagues can certainly help come up with a plan and find the right reorganization, the right bankruptcy if that's appropriate. But I can't stress enough that it's not going to be business as usual. Unfortunately, I think we had all hoped that on a date certain, everything changes. We go back to partying, go back to the garden or the arena to see games. It's not going to be like that. And I think you have to be using this downtime for good. I like to tell everyone, use your downtime to look at your human capital and practices in HR. But more importantly, if you're going to get through this, you have to be reimagining the business. And we've had a lot of incredible changes in technology. We've had delivery companies and third parties coming up to do all sorts of new things. You have to make sure you understand what's there for you and how you can reimagine your business for the future, because I think we can all agree it's not going to be like it was. Those in New York have seen the paper the last few days. One of Sammy's Romanian announced that it was closing, and everybody's all upset. It's not a client, one of my favorite restaurants. But when you think back and imagine those amazing times you had in an unbelievably cramped Lower East Side space and putting in 200 bodies where the occupancy was probably about 70, it doesn't even sound fun anymore. So it's about getting the right space, and it's about reimagining what you can offer and how you can offer it going forward.
Excellent. That's a good point. So I think we're getting close to the end of the session. If there are other questions, please go ahead and let me know. I know that there was a follow-up on the EIDL loan. The question, the participant wanted to know if, is it forgivable or is there a personal guarantee on the EIDL loan? I'm not sure about that. Mark, do you know the answer to that?
You know, I'm not an expert on the EIDL loans. They're not forgivable. I know that. The PPP loans are the ones that are forgivable. Those are the ones that are much sought after. The personal guarantee component, I don't know that there's a requirement for a personal guarantee for an EIDL loan. I haven't heard that, but there are certainly, I can tell you at Fox, we have a lot of experts in EIDL loans and what's happened with the CARES Act. And if whoever wants to follow up with me, I'd be happy to follow up with one.
And Mark, I think we could probably get the answer, and Brad, we can have you guys post that answer. Sure. I think we've certainly put out dozens and dozens and dozens of alerts, so we'll get the answer on the loan and the personal guarantee.
Okay, sounds good. Let's see. I'm just looking. There's another subchapter 5 available for a situation where a client has purchased property out of state for an investment. I don't know. And this is a kind of an involved question this is the kind of thing that when we start seeing these questions, it's good because it means that people are really thinking about what subchapter 5 can do. And I think that it also speaks to the point that we were making earlier, which is that if you're in a situation where you're facing a lot of debt, but you still believe your business is viable, you really need to talk to somebody. You guys deal with this stuff every day. You've dealt with, I'm sure, dozens, if not scores, of businesses that are in the same boat, in the sense that they all have debt, but they all believe their business is still viable. So it sounds like seeking wise counsel is the first step toward sorting out what you can do and how you would go about it. Is that accurate?
That is accurate. It's well said, Brad. I mean, if there's no limitation on like where your property is located, if they're, for instance, if you have your business located in one state, but you deal with property in another state, that shouldn't stop you or, in any way, or thwart you from filing an effective subchapter 5 bankruptcy. I did want to mention one other point, though. I think it's important, and it didn't come up before. In I have one of my cases, this is an issue where, in one of my restaurant cases, where and this is unique to subchapter 5, which is the reason why I'm mentioning it. If you have a mortgage that's tied to your home, as long as that mortgage wasn't secured primarily to purchase the home to live in, you can actually modify the secured debt tied to that home under subchapter 5, something you couldn't do before subchapter 5. And this plays out in one of the cases where I am a trustee, and there's a restaurant owner who has who lives in the building where there's a restaurant, nightclub, liquor store. There's a lot going on, and there's a mortgage taken out on the property. He lives there, but it's not primarily for his residence; it's for the business. And so there are these other elements. If you incur debt towards a business, either as an individual or on behalf of your business, and it's attached to your personal residence, there is a way to minimize the damage that would be owed to a secured lender in that situation. And it's called the Small Business Restructuring Act, but individuals can file a bankruptcy under the SBRA as well, as long as at least half of the debt that they incurred is related to their business. So these are just it's something to keep in mind if in fact you have debt tied to your personal residence, and if it was used to save your business. This is not an uncommon story where people are willing to mortgage their home in order to put money into and help save a business. Well, here you have another tool at your disposal that you didn't have before subchapter 5 that actually allows you to negotiate with secured lender in a significant way, even if it's tied to your personal residence.
Excellent. That's very well said. I think one other quick element is, I think that if I'm not mistaken, that the subchapter 5 is due to sunset in sometime in March, I think, or April. Is that right?
Well, it is it's not due to sunset its entirety. The debt limit was raised from 2.7 million to 7.5 million. That the raising of the debt limit to 7.5 is what's set to sunset on March 27th. The hope is that will be extended beyond March 27th by the next Congress. But right now it is the sunset. But the SBRA will still be in existence. It just you won't have as many businesses be able to take advantage of it because the debt threshold will be lower if it gets, if it lowers back down to its original amount.
It sounds like what you're saying is now is the time to start investigating what you might want to do.
Right, in terms of timing, absolutely. I mean, March 27th will be here before you know it. If you have an opportunity to consider this, if any of this makes sense to you, like Robert said before, at least I would be happy to talk to you and find out whether or not there's a plan forward for your business that makes sense under this avenue.
And I think it's probably safe, Mark, this is more for you to answer, but as we go into a new administration and we see what happens finally with Congress, there's a lot of pending proposals out there. And I think we're going to see probably a lot of change and a lot of additional opportunities for small business. And I think that will start to come later this first quarter, probably.
It's a good thing to bring up, because I wanted to make one final note here, which is that we touched a little bit on crowdfunding, talking about business opportunities. We touched a little bit on crowdfunding, and I wanted just to make note that the Florence Belsky Foundation is actually addressing that. So maybe Rivka, you can speak a little bit on that subject.
Yes, I can. And it's 4:30, so I want to just thank you all so much for joining us. Thank you to our panel, Robert, Carolyn, Mark, Robert, Brad, getting everyone. This was a really, really important topic. You guys covered so much. For everyone watching, this is recorded, so I know there's probably a lot of notes to be taken, and we will give you this as a resource so you can go back. And thank you to our partners who who helped us put this on, the Hatch Institute, Fox Rothschild LLP, the New York City Hospitality Alliance, Traxi Business Solutions. And thank you to Goxstein Media for streaming this event for us and helping get this important information out to audiences who need it. And to your point, Brad, yes, we're having upcoming webinars, a series that this is the first of, and we're going to touch on Reg CF crowdfunding, mergers and acquisitions, and other turnaround tools. So for more information on that, you can visit our website, flowbell.org. And we will also, since you've all signed up, we'll just we'll make sure to follow up with all of you and let you know when those webinars are coming your way. Thank you all so much. I hope everyone has a beautiful, beautiful day.
Thank you so much, Rivka, for having us, and Brad and Dan as well.
Yeah,
Thank you
very
all.
much.
Thank you.
Appreciate it.
Bye, everyone.
Thank
Take
you
care.
all. Have a great day. Happy New Year. Thank
Happy
you.
New
Bye.
Year.